All right, good morning to everyone. We are here this morning in the case of the state of Florida versus Charles Adelson. It's 2016 CF 3036. And looks like we have Mr. Evans and Ms. Stugan on behalf of the state, and Mr. Roshbaum, Ms. Myers, and along with their client, Mr. Adelson. Good morning to everyone.
Good morning.
All right, we're here today on a couple of things. First of all, we have a case management, which necessarily includes the motion for continuance that was filed just recently, and so we'll address that second today in our proceedings. The first thing that I'd like to address is the defense motion for a protective order, and that was filed back on January 10th of 2023, and that was regarding any reports or recordings or interviews of Ms. Magbanua and the sealing of those. Those were interviews taken by the state that took place after the trial, and so the defense has moved for the sealing of those. And that was filed again back in January. So, Mr. Roshbaum, will you be arguing this motion?
Yes, Your Honor.
Okay, and so would you like to present any argument? First of all, have these items been provided to you? Have you reviewed the items?
Yes, Your Honor. The two proffers have been provided.
Okay, great. And would you like to present, I've reviewed your motion, of course, and would you like to present any argument?
Very briefly, Your Honor.
Okay. Yes, you may. Mm-hmm.
So, Judge, we asked for a protective order without knowing what Ms. Magbanua had said. When we asked for it, we had not received the items, as you're aware of. We've now received that information. We renew the request. It's unopposed by the state. Judge, I think you've seen the proffers. I don't know if you had an opportunity to review it.
I have reviewed them.
But we renew that request even though we don't find the proffers to be incriminating against Mr. Adelson. Rather, we believe that the proffer should still be sealed just because it's the right thing to do. And what we would say, Your Honor, is that we understand that the public has an interest in access to these materials. But as cases like McCreary reflect, that presumption must yield to a defendant's right to a fair trial. The media that opposes our motion doesn't dispute that fact, nor do they dispute the fact that media attention in this case has been extraordinary. They argue that isn't enough. To be sure, the media cites a number of decisions, the majority of which were handed down before social media and other videos and news sharing sites had even existed. If what's happened over the last few years is any indication, we're not just talking about a few more articles of the kind addressed in the cases that the media cites, which don't anticipate not just the articles, but also the podcasts that will come, the web-based panel discussions that will come, the TV specials that will come, the YouTube discussions that will come. All of that has the ability to unnecessarily taint the veneer in this case. The media's counter to that argument is that because of the nature of the case and the high intensity of the public's interest in it, it has been and will remain in the media spotlight. We don't deny that. So anything that comes from the proffers, that if they're released, will just be a drop in the bucket. Well, what their response does not appreciate is that release of those proffers could cause a whole host of problems. We anticipate that Ms. Magbanua will not be called as a witness at trial after seeing those proffers. Maybe we're wrong, but we anticipate she won't be. The media could focus on one little piece of those proffers, take a snippet of those 4+ hours of discussion, and that could taint the veneer unnecessarily. The media argues that there are a bunch of other alternatives. They bring out moving the trial, sequestering the jury, expanding the veneer, some of which I think you're already going to do. But Judge, with respect to all of that, that's so extreme given that we are just asking to withhold the release of those proffers for months, not years. To us, the balancing test that you need to do under both the Florida law and the U.S. Supreme Court law is a simple one, and the proffer should remain sealed until at least the jury's selected, and at most until after the trial is completed. Judge, I'm happy to answer any questions, but that's our approach to the issue.
All right. Thank you, Mr. Roshbaum. Okay, does the state want to be heard, Mr. Evans or Ms. Dugan?
Your Honor, just like I said, we are not opposed to the motion. Our primary purpose is and focus is, as the court is in considering this, that we want to ensure the defendant has his constitutional right to a fair trial, and we would want to do everything we could to avoid any possible change of venue in this case. It needs to be tried here in Leon County, so our position is we'll abide by the court's order. We would simply request that it address, and if it issues a protective order, that it indicate to us that we're not to allow to disclose these as public records, because we've had a number of public records requests for them, as you would naturally anticipate.
All right, thank you, Mr. Evans. Okay, as required by case law, we've sent out notices to several members of the local press. That would include WCTV and their parent companies and Tallahassee Democrat, and given notice for them to appear here and present any argument that they choose as they're entitled to. They have requested Mr. Tobin on behalf of Gray Media Group has asked to appear by Zoom, and I have permitted that. Mr. Tobin, are you there? Can you hear me? Well, it looks like I might be on mute here too. Mr. Tobin, can you hear me? All right, good morning, Mr. Tobin. I think you might be on mute. I can't hear you at this time. Let me just make sure and check. Okay, Mr. Tobin, I thought that you were on earlier, but I think you were not, and so I'm going to repeat that we are here on the motion for protective order that was filed by counsel for Mr. Adelson, and I think you have reviewed that motion, have you not? All right, and I did receive your memorandum in opposition, and I have reviewed that. And so we're here today on that protective order. Mr. Rashbaum presented a short argument in favor of the sealing of the items, the interviews, the proffers that took place of Ms. Magbanua after her trial. And so now is an opportunity. I sent out a notice to a number of media groups, and you responded on behalf of Gray Media Group, and I want to give you the opportunity to make your argument before the court makes a decision in regards to the sealing of this proffer. So would you like to make your argument at this time?
Thank you very much for providing notice to the news media and to me personally, and for giving me the opportunity to appear today by Zoom. Your Honor, I'm here on behalf of both WCTV, which is owned by Gray Television, and also Court TV, and we're here opposing the motion to seal because under Florida Public Records Law 119.011 3C5, which is also enshrined in the Florida Constitution, so it's both a constitutional right of access to public records and a statutory right in Florida to public records. The records of Ms. Magbanua's proffer, which I understand have already been turned over to the defense by the state, are public records, and it's not just a presumption, it's a statutory definition that by statute the legislature has designated that they are public records once discovery material is turned over to the defense. And under the case law that comes out of the statute, in which the courts have interpreted the statute, and we provided the court with actually 4 decisions that are either out of the first ECA or out of courts within the first ECA. The presumption, the statutory definition of a public record in this context can only be overcome if the defendant in this case can satisfy his burden under the 3-part test. The test comes from Miami Herald Publishing Company versus Lewis in the Florida Supreme Court. It was adopted in this context, the Chapter 119 context, by the Supreme Court in Florida Publishing versus McCrary. And then within the 4th ECA, it's been interpreted, as I said, at least 4 times. And under the precedent, it is Mr. Adelson's burden in this case to demonstrate that closure is necessary to prevent a serious and imminent threat to the administration of justice, that there are no less restrictive alternatives to closure, and that there is a substantial probability that closure will be effective in protecting against the perceived harm, whatever demonstration they have made of a serious and imminent threat to the administration of justice. And in interpreting this statute, the Florida Supreme Court has made clear that is an evidentiary burden. This is an evidentiary hearing, or at least an opportunity for one, in which Mr. Adelson is required to come forward with evidence, because a court's ruling in this area must be based on specific findings warranting closure under the three-part test, and, quote, cannot rest on air, close quote, according to the court in McCrary. And so, Your Honor, under the four precedent cases that we've cited within the fourth DCA, and I might add, I've been involved in two of those, and all four of them were high-profile cases in the moment that they were before the circuit courts. In all four cases, none of the courts within the first DCA found that on the records that were far more fulsome than Mr. Adelson's record in his motion, that the defendant or the state, whichever was the moving party, had met their burden under the three-part test. And so, Your Honor, in Florida Publishing Company versus Shorstein from 1992, that was my case when I used to practice in Jacksonville, Judge Deering had found at the circuit court that the community had been, quote, saturated with coverage. Notwithstanding that, and it was a murder case, it was a vigilante murder case, Your Honor, that notwithstanding the finding of saturation, the first DCA found that nothing would warrant a finding that whatever the publicity had been, that it would pose a serious and imminent threat to the administration of justice. And so it ordered that my client be provided with the witness statements, in that case that had been given to the defendant, and we moved forward from there to Morris Communications versus State, another case out of Jacksonville, in which the trial court, according to the first DCA, this is the first DCA case, had found that the trial court had not made a specific finding that the pretrial publicity was sufficiently, quote, hostile or, quote, open quote, adverse to warrant sealing the public records, and therefore there was no demonstration by the defendant of a serious and imminent threat to the administration of justice. In that case, the records that were ultimately ordered turned over by the DCA were search warrants, instant messages between the defendant and the victim, a recorded phone conversation inculpatory of the defendant, a videotaped interview of the victim, and the police offense report. That was a high-profile case in Jacksonville involving the molestation of young boys by a Baptist preacher in a prominent church in the community. The next case we cited, Your Honor, was in Tallahassee. It was another case that I was involved in, State versus Smith. It was a first-degree murder case before Judge Cooper in 2006. And Judge Cooper held that the defendant had not demonstrated, despite a sizable record of publicity of prior reporting, that the prior publicity was widespread adverse publicity, such that it would constitute a serious and imminent threat of the defendant to the defendant's right to fair trial that would preclude the fair administration of justice. Judge Cooper also found that under the second part of the test, the defendant had failed to show that there were no alternatives: continuance, change of venue, voir dire, peremptory challenges, sequestration, admonition of the jury. The defendant had not shown that those were not available to ameliorate any concerns about the administration of justice. And so Judge Cooper ordered that my client, WCTV, in that case, be given surveillance tapes of the apartment in Tallahassee where the murder had taken place that showed the defendant traversing the area. And then finally, when we cited to the court State versus Williams, a case out of Jacksonville, where the court expressly noted that there had been extensive pretrial publicity surrounding the case. That case received nationwide attention because it was about a woman who had kidnapped a baby from a Jacksonville hospital 20 years earlier, taken her to North Carolina, and then was arrested finally 20 years earlier, and the woman was already an adult, received extensive, widespread national publicity, but according to the circuit court there, the defendant had not established as a matter of
Mr. Tobin, I'm going to interrupt you for 1 second. There's something going on outside the courtroom. We have some noise. I'm going to wait for that to calm down for just a moment. I'm sorry to interrupt you. The court reporter was having a hard time hearing.
sound like the truth.
All right, Madam Court Reporter, are we okay now? Okay. Let me just mention that it appears to be completely unrelated to this case, but it was something else going on outside. So you may proceed. Thank you.
Thank you, Your Honor. And so, Your Honor, I was just deciding from State versus Williams, which is a trial-level decision that we attached to our opposition papers, that even if the court found that even though there had been extensive publicity surrounding this high-profile kidnapping case, defendant had not established that such publicity so far has been overwhelmingly adverse and that no alternatives to closure would protect the defendant's rights. The court also noted that the amount of time between the motion hearing, today's hearing, and the trial is a relevant factor in considering any amelioration of any concerns that the court or the defendant might have. So here, Your Honor, just applying that precedent, Mr. Adelson's motion does not meet his standard, his burden, for justifying the closure that he seeks, for overruling Florida's statutory right of public access. First of all, there is no evidence that I have seen in the case. Obviously, I wasn't here when Mr. Magbanua's Mr. Adelson's counsel was cited today, but I've received no evidence. There's no evidence put in with the motion to demonstrate what level of publicity is, whether the court can make a basis for a finding that it has been overwhelmingly adverse, and the other particular findings that the case law say really matters, not the amount of publicity, but the nature of the publicity. So there's no record before the court of hostile, widespread, overwhelmingly adverse publicity, such that under Morris Communications or State versus Smith, the court could premise a finding that there is any threat at all to the fair administration of justice in this case. Second of all, Mr. Adelson's counsel has not proposed, has not demonstrated that there are no less restrictive alternatives to closure. For example, and that the ordinary tools at the court's disposal wouldn't weed out any potential prejudice, just like any other case. Your Honor, I appeared before you briefly in the Magbanua case on behalf of a journalist on a motion to quash basis. I did not participate in the Magbanua trial or the other trials in connection with Professor Markel's murder, but I'm unaware of any serious impediment the court had to seating a fair and impartial jury in those cases, such that voir dire, just for to recite one tool from the case law report's article, wouldn't ameliorate any concerns. I'm sure the court will do its job, Mr. Adelson's counsel and the state will do their job to make sure that a fair and impartial jury is seated. Second of all, Your Honor, I note that the trial is 2 months away under the current schedule, but that Mr. Adelson's counsel filed a motion last week asking for the court to extend the trial date until July or August. So if we if we do receive Ms. Magbanua's Proffer information today, which is what we're to order, there's still plenty of time ahead of us for the information to be publicized and for any concerns to dissipate. And that is a factor that the courts are instructed to consider in the case law. Finally, Mr. Adelson has not demonstrated that there is a substantial probability that any sealing would be effective of the contents of Ms. Magbanua's Proffer. The previous trials in this case are on YouTube, Your Honor. I've watched some of them. There is plenty of information already out there about Mr. Adelson's alleged involvement in Professor Markel's murder that came out through questioning and counsel arguments in those previous cases. Second of all, Ms. Magbanua's order to transport, which the court entered on November 16, states very plainly that her presence was being commanded in Tallahassee in order to offer a proffer, and she was identified in the court's order as a state witness. And so there's really no secret. It's been a matter of public record that Ms. Magbanua is cooperating in some fashion with the state. And then finally, I would just quote from the Smith case where Judge Cooper noted in analyzing this third prong that since much of this information has already been made public, there is little justification for granting this motion. And so, Your Honor, Mr. Adelson simply has not met his burden, and it is a stringent burden under the three-part test. And therefore, WCTV and Court TV asked the court to deny his motion and order the immediate release of the public records that have already been provided to the defendant. Thank you, Your Honor.
All right, thank you, Mr. Tobin. Okay, we had a few other people that entered into the room here, and so let me make sure that we don't have anybody else that needs to be heard in that respect. All right, Ms. Walker is counsel with you, is that correct, Mr. Tobin? All right, so Ms. Walker is on the line, and then I don't see anybody else. The person who was on the line just got off. So I did send out other notices to press. Is there anybody else here in the courtroom on behalf of the press that needs to address the court? All right, okay, thank you. All right, and thank you, Mr. Tobin, for your thorough presentation here today. The defense has filed a motion to seal Ms. Magbanua's interviews or proffers that were taken by the state after her trial. The defense has stated that in their argument that they don't think that those would be damaging to Mr. Adelson, but certainly there's going to be varying interpretations of that as we proceed towards trial. The court has reviewed the interviews, and as Mr. Rashbaum noted, this is a balancing test for the sealing of the evidence. There must be an overriding interest that is likely to be prejudiced if the items are released to the public. There needs to be a serious and imminent threat to the administration of justice, as Mr. Tobin has noted. In this case, that interest is the defendant's right to a fair trial by an impartial jury. The court recognizes the public's right to the public record, but in this case, the defendant's need for a fair and impartial jury overrides that public interest. It's the responsibility of the judicial branch to ensure that all parties receive a fair trial. As Mr. Tobin noted, there is a three-part test in the Miami Herald versus Lewis case that this court must adhere to. And in that three-part test is met for the sealing of these proffers. Number one, there has been a wealth of pretrial publicity. It's a well-known case, particularly in this community. Number two, the public disclosure of that discovery material would further aggravate the pretrial publicity. It would draw attention to this case, particularly in this community. And number three, the only measure available to the court until a jury is selected is to cut off the potentially prejudicial publicity at its source before it's disclosed to the public. The disclosure of these discovery materials would be big news in this small community, potentially infecting the entire jury pool, even those who at this point may be acceptable jurors. Those without an opinion at this time may form an opinion, thereby reducing the jury pool drastically. This sealing is limited as much as practicable until Ms. Magbanua testifies at trial or until the conclusion of the trial. So in short, the sealing is necessary to prevent a threat to the administration of justice. There's no other alternative that is available, and the sealing is no broader than necessary to accomplish this purpose. Therefore, the motion is granted. Mr. Rashbaum, I'm going to ask that you please prepare a short order for the reasons that the court has provided on the record at this particular hearing, that the motion is granted and the discovery items, the proffers, will be sealed until Ms. Magbanua either testifies at trial or until the conclusion of the trial. Okay, that's my ruling, and if you could provide that to me either today or tomorrow. I know that you'll probably be traveling, and then I'll get that signed, and then whatever action needs to take place after that, Mr. Tobin, I'll leave that up to you, sir. Okay? Now we're going to proceed with the case management. At this point, you're welcome to stay on or get off of the Zoom as you see fit. Okay, sir? All right, thank you. All right, so the case management, so we need to address first the motion for continuance. And so, Mr. Rashbaum, would you like to present your argument in regards to that?
Sure, Your Honor, may I do so from here?
Sure, that's fine.
Judge, we've been working very hard with the government to go through all the materials, make sure we have all the materials. I believe we have most of the materials at this point. We are also just received, I think, about 70% of the second trial. So we have most of the transcripts from that trial, although we haven't begun reviewing them yet. Judge, I didn't want to, I thought we might be able to be ready by May, but I didn't want to surprise the court. The truth is, we just need a little bit more time. And I wanted to give ourselves a little bit of breathing time so that we could adequately review the second trial, also continue to adequately review the wires with our client. And so that's why we're asking for a very short continuance.
All right, thank you. Ms. Dugan?
Thanks, Judge. So the state objects to a continuance. The defense selected this trial date along with us as a date that we would be ready for trial. I know they have been working hard to prepare, but they still do have another 2 months before the beginning of trial to continue preparing and get that preparation done. Since the time that we all selected this date together, Ms. Kappelman and I have planned our schedules around this date. We've cleared our trial schedules in April and May to focus on this and have this trial during that time. We've set our other murder trials during the summer and the fall. Continuing this one could have a domino effect on those, cause those cases to be continued, many of which are several years old. So we oppose a continuance, and the family of Dan Markel, they don't want to be heard today, but they did want the court to know that they oppose the continuance as well.
All right, thank you, Ms. Dugan. All right, I think it goes without saying we've all planned our schedules around the anticipated trial. Everybody in this courtroom probably has done that, but there are times that things change, and the court understands that. I don't think that a motion for continuance, given the gravity of the case and the amount of material that defense has to review, is unreasonable at this time. I know that both parties have worked hard. It's not through any fault of anyone. It's not an unreasonable delay or for lack of any effort to get ready for trial, and so I will recognize that for both parties. I'm going to grant the motion for continuance, and we're going to need to get dates set then, looking ahead. The dates, and I'm not going to set these right now because I'm going to need to set all the discovery deadlines and pretrial motions in accordance with this, but you asked Mr. Roshbaum for the end of July or into August, and August and September are tough months for the court. There might be an opportunity, I don't know if starting the trial on July 17th would be the end of July for you. I was looking at the weeks of the 17th to 24th and the 31st. Okay, so maybe everyone wants to take a look at that. The month of August is very difficult for the court, and also the month of September. If we don't get it done in those 3 weeks, and we can take another look at the calendar, then if there's a possibility it could be even pushed to October. I don't want to do that, and we're going to try not to do that, but also I don't want to run into a situation where we set it for those 3 weeks in July, and then we're in a situation again like this where we're delaying it and having to move it again. I'd rather have it set and so that we all have some certainty. So I give those dates to you at this time so that you can go back, check your calendars. I'll take a little bit more time reviewing some things, and then the court will send out emails and we'll try to get something set based on your calendars and get 3 weeks set aside either in July or it might even be later than that. Ms. Dugan?
Could the state be heard as far as
Sure.
scheduling? Okay.
Mhm.
Ms. Kappelman and I, and we've shared this with Mr. Roshbaum, so he's aware, we're both unavailable at the end of July and first week of August for several personal conflicts she and I both have.
Okay.
I know that at mid-August, she and I both have first-degree murders, other cases set then. We were going to ask, we had preliminary kind of talked about September, which we've heard now is hard for the court, or June.
It might be able to be later September. We might,
Okay.
all right, that's good to know, because I really was looking at those weeks in July, but if you've already had discussions in regards to that, so we're probably looking at either starting in late September and then maybe going into October. So, all right, let's just digest these dates at this point. So the end of July and the first week in August is out for you?
Yes, sir.
Okay. And what if there's other weeks, the last 3 weeks in August? Was that more difficult?
She and I both have first-degree murders then. She has the Aaron Glue case. I have Fernando Gibson and Terrell Jones. We don't, those are the conflicts we would have.
Okay. All right, knowing all this information, let's go back, take a look. The way that I usually do this is I make the proposal out to you all and see if everything fits. And so we'll do that in our conversations later in the week, and we'll try to get something set. Mr. Rosbaum, do you need to be heard on any dates or anything?
The only problem I have is mid-October, which is, I have a family event on October 14th. That's going to take me out of pocket a little bit before and a little bit after. So that's the only conflict I have.
All right. Let's take a look at maybe where we can get to the end of September and then the beginning of October. I think that might be the best. I'd hate to have to put it after that, but after the October 14th date. We're all going to have some issues, and so we're going to have to be flexible in that regard. So let's take a look at our calendars, and then I'll send out some proposals, and then we'll make decisions later in the week or in the next couple of weeks, okay?
Thank you, Your Honor.
All right. Any other issues that, other than setting the case, anything in regards to discovery or any other issues that we need to discuss at this time? Ms. Dugan?
Yes, sir.
Mr. Evans, we all good?
Yes, sir.
Mr. Rashbaum?
No, Your Honor.
Okay. All right. So it looks like we're set. We'll get those dates out and have discussions on setting the trial. And if you get that order to me as promptly as possible, then I'll get that signed, okay?
Thank you, Your Honor.
All right. Thank you, everyone. Have a good day.
Yes, sir.
Mentor lawyer with my reaction to the court's rulings at the hearing involving the state of Florida versus Charles Adelson case. Specifically, of course, the court granted a continuance. I'm going to talk about that later. So the trial is not going to happen at the end of April. It's going to be moved to some other date. We don't have the date yet. And then also the court ruled in favor of Mr. Adelson on his motion to keep the Proffer videos of the confessions of Katherine Magbanua sealed until the end of the trial, or until after Katherine Magbanua testifies at the upcoming trial in the case of State of Florida versus Charles Adelson. I'm standing here at Dorothy Oven Park, not too far from where FSU law professor Dan Markel was murdered, was shot in broad daylight by two hitmen from South Florida. The two hitmen were Sigfredo Garcia and Luis Rivera. Sigfredo Garcia shared two children with a woman named Katherine Magbanua. Katherine Magbanua, at the time of the murders, was dating Charles Adelson, the defendant. Charles Adelson is one of the two older brothers of Wendy Adelson, who at the time of the murder was a professor at FSU Law School. And Wendy Adelson's ex is the victim in this case, Dan Markel, Professor Dan Markel. Professor Dan Markel was murdered back in July of 2014. because, as the state alleges, one or more members of her family wanted him killed. Why? Because they wanted Wendy Adelson to be able to move back to South Florida to raise the kids without having to have the pressures of Dan Markel as far as how to raise the kids, about how much religion to introduce to the kids' lives, about whether to keep a kosher diet or not. All those differences in how the two sides wanted to raise the kids would be gone. Wendy would get to pick everything. And more importantly, of course, she would be able to go to South Florida and be with her parents, her brother Charlie, have a fun life, and would not be stuck in this awful city of Tallahassee, Florida, where really there's not a lot of fun things for somebody like Wendy Adelson. That's the gist of what happened. That's the gist of the allegations of the state of Florida. They already have convicted Sigfredo Garcia. Rivera took a plea deal. They convicted Katherine Magbanua, who now has given a confession. So that confession is now going to be sealed, unless, of course, the Court TV and WCTV file a notice of appeal, and the First District Court of Appeals reverses the order from Judge Wheeler. I think that if an appeal is filed, I think it is very likely that the order would be reversed. But regardless, there will be a delay in the production of the proffers, because an appeal doesn't just happen overnight. You have to file the petition, and it will take some time for the briefs to be filed or the petition to be filed, the court to hear any response from any other interested parties, and the court making a decision on the case. So there's a delay no matter what. My opinion about the ruling is I'm disappointed with the ruling. Of course, I'm a little bit biased. I would love to have a copy of the Magbanua proffer today, publish it on the channel so we can all take a look at the actual facts. What did she say? How much different is her story from what we understand the story to really be? Did she corroborate some of the things that other witnesses said about how, for example, the hitmen were paid, the staple cash, all of that? It is a part of the puzzle, right? It is a part of the puzzle. Her change of tunes, right? Because beforehand, her testimony was that she was not involved at all. These were all coincidences. These were dealings between Charles Adelson and Sigfredo Garcia, her ex, outside of her, without her involvement. So now she has given a confession. She's sort of turned state witness. What do I think is unfair about the ruling? Number one, if the whole interest here is to protect the venire, to protect the group of people from whom the jury will be selected, to make sure that they don't have biased opinion or have made a prejudgment about who's guilty, who's not guilty, about Charles Adelson's involvement in the murder, so that jury selection can occur smoothly and so that a fair and impartial jury can be selected for Charles Adelson. That's what supposedly Charles Adelson is seeking by filing this motion. Yet, the attorney for Mr. Adelson, Rushbaum, gets up and starts to argue in favor of keeping this sealed. And in the process, he's discussing the content of the proffer in a very biased, perhaps way, in a way where he claims his interpretation of the proffer is that it's great for his client, it doesn't implicate his client. If you want the proffer sealed, if you want to keep the information about the case under wraps, if you want to prevent speculation in social media and so on and so forth about the case, then you wouldn't say anything about the proffer. You definitely wouldn't be given your interpretation of what Magbanua said in an open proceeding, in open court, for everybody to listen to and react to. A soundbite for the media. right? The soundbite is Adelson's attorney says Magbanua's proffer does not implicate her client. So now he puts a soundbite out there that will invite speculation in the media, in social media, and all that stuff. And yet, he's still asking for the actual facts, right? The actual confession that we can all evaluate and decide whether or not it does or does not help his client. But he invites the speculation that it doesn't, that it's hurtful to his client, and people will be trying to analyze why is it helpful to his client. Why is it helpful to Charles Adelson? So he gets to share his interpretation of the proffer. The state says nothing when they get an opportunity to respond. They don't say anything about the contents. And then the judge himself also interjects the counter response that probably should have come from the state. The state maybe should have gotten up and said, well, Judge, we disagree with this interpretation shared by Charles Adelson's counsel about what the proffer is or does, or how good it is or how bad it is. We disagree with that, but we agree that in general it should be under seal until whenever, the end of the trial, or until after Magbanua testifies. Fine, that's your position, state. Then at least correct the attorney, don't stay silent. Instead, we hear from the judge. He says, well, I've watched the interviews. So he was given a copy of the proffers. I watched the interviews, and I think it is subject to varying interpretations. So he's sort of responding to what Rashbaum did. Rashbaum says, well, this is really good for my client. The judge saying, well, there are varying interpretations of what happened in that proffer, or those 3 proffers, or 2 proffers, whatever the number is. And so kind of hinted at the fact that, well, maybe it is hurtful to Charles Adelson, or maybe someone else. We don't know. The bottom line is that this ruling, because the judge granted Adelson's motion, this ruling only will invite more speculation from social media, from whatever, even from the regular media. And it will invite the distribution of misinformation in a sense, because the media gets a soundbite from Rashbaum. That's going to go around the media, because media likes soundbites. That's what they like. So that's going to be the news, right? All for the benefit of Mr. Adelson. So a big win for Mr. Adelson, I would say. And I think an unfair ruling from the court. I also think it's totally wrong the fact that the judge says that there are no alternative ways of ensuring that there is a fair trial for Mr. Adelson. I think that the attorney for the media provided excellent arguments in that regard, and it clearly stated the truth, which is that there was no issue in paneling a fair jury for the Magbanua trial. Why would it be any different now that the proffer is out, if the proffer were out? I really think this is going to invite more speculation from all the YouTubers that cover the case about the content of the proffer. I don't want to speculate. I don't believe, and I don't take Rashbaum for his word, and I don't think that you can interpret the statement of Judge Wheeler as saying anything substantive about the proffer, other than to maybe a slight disagreement regarding the interpretation that Mr. Rashbaum gave of the proffer. The bottom line is, I want to see the actual proffer and make a judgment based on the facts, based on what she said. Is she still lying? Is she still trying to diminish her own role in this case? Is she implicating any other Adelson? Is she making the case against Charles Adelson stronger? Those are all things that I wanted to do by actually looking at the proffer. And now we're precluded from doing that until there's a reversal of the order or until after the trial because of this ruling. I respectfully disagree. I think Judge Wheeler is a great judge, and I don't in any way wish to disrespect him as a judge. He's a great judge, but I disagree with his ruling. I also think that the judge and the state already should have moved to unseal the the phone calls, the jail calls between attorney Tara Kawas and Sigfredo Garcia, and also to unseal the recorded call during the trial of Magbanua, I believe it happened, between Magbanua and Sigfredo Garcia. Why are we keeping all those stuff secret? Again, secrecy to me invites speculation. I think the state of Florida has the legislature in place to make decisions about what the law should be. And I think that we also have a constitution in the state of Florida, both of which are heavily tilted towards the openness of our government, the openness of our judicial system, of our criminal justice system in particular. And if any changes to that have to be made because of what happens in social media, because of, for example, what's happening in the Idaho 4 case with hundreds and thousands of people giving their crazy opinions about the case, maybe that's something that the legislature has to decide. Maybe that's something, an amendment to the Constitution can be made. But the fact is that the law is clear, the proffers are public records, and there is a very stringent standard under which things that are available to the public and made available to the public by law should be sealed. It was not met in this case, in my opinion. There's no evidence presented by Mr. Adelson to indicate that there was a necessity to get this done. Obviously, there is an agreement from everyone that there is a lot of coverage about the case, but that in itself is not enough. That in itself is not enough. So there is no basis, to me, factual basis for the court's ruling. I think that if this is appealed, it will be easily reversed. Regarding the continuance, I understand that this case has been set not very long ago. It's a very short continuance that the attorney was asking for. I totally understand the judge's ruling. I think it's the correct one to give the defense more time, and that's fine. But I would invite most people not to speculate about the contents of the Magbanua proffer based on what Mr. Rashbaum said or based on what the judge said. Bottom line is, I hope that someday we'll get a hand of it ourselves, and then we can actually evaluate it properly and fairly, and then discuss it then. Mentor Lawyer here. I also wanted to add that the major commotion that was going on outside of the courtroom had to do with a fight. Had to do with a fight in outside of another courtroom, outside courtroom D. In essence, there was a juvenile hearing going on in a murder case, a juvenile murder case. And the family of the victim and the family of the accused got in a fight outside of courtroom D, which is close to courtroom G, where we were having the hearing. So that was a major commotion going on that interrupted the hearing, and that's exclusive here on this channel. I obtained that information by speaking to two of the officers that were involved in trying to quash the commotion. Thanks for watching, Mentor Lawyer. Thanks for watching. Until next time, Mentor Lawyer.
Oh, we're allowed?
But not yet, not yet, not yet.
Okay.
He's gonna go first.
I'm gonna take him back.
Can I go to the restroom?
Yeah.
Okay.
I'm gonna take him to the holding area back here.
Okay.
Thank you very much.
Thank you very much. We
Really
really
appreciate it, thank you.